The people, through their respective constitutions, granted authority to Congress and state legislatures to adjudicate only a few matters: actions at law, which meant the common law; actions in equity, which means contract law; and actions under the rule of necessity, military, called admiralty law. Admiralty was remanded to the federal government, and the states are supposed to not have any authority to legislate in this jurisdiction. There was a time when someone aggrieved of harm would file a tort at law. The tort is a damage, and the nature of the action governed the rules of the procedure. If there was a breach of contract, then this was an equity matter. If the aggrieved party could allege a tortious breach of contract, a damage during the contract, this matter was moved from the equity side of the court into the law side. This is because the people must have access to a remedy at law if this type of action could give relief. If one were in the military, or if one were under a territory under martial law, the court was a military court. If there was a breach of international contract, the matter was federal and heard under admiralty. The Congress nor the state legislature cannot vest a court with authority that has not been delegated to it by the people via the Constitution of the state. They cannot create a new nature of action out of thin air. Later on, when the constitutions of the several states were amended to recognize and administrate corporations, a separate court was established, and the action was in the nature of administrative. Human beings could not be brought into administrative courts, as the only matter at issue was a breach of corporate charter by an artificial entity. Somewhere along the line, the announcement of the complaint of the nature of the action was lost. The attorneys all got together and decided that it would be much easier and simpler for them if there would be only one form of action. So today there's no disclosure of the nature of the action unless one demands to know the nature and cause of the accusation by using a demand for a bill of particulars. I've been quite successful with this procedure, even in states that have decided that a demand for a bill of particulars is a discretionary motion before the court. Some states, the demand for a bill of particulars used to be prior to arraignment, so that one had an opportunity to raise a meaningful defense against the elements of the personal jurisdiction and venue, to include territorial jurisdiction as well as the nature of the action that used to be part of the subject matter jurisdiction. In the past couple of decades, they've moved it into discovery, which is after arraignment. So the ability for one to challenge the jurisdiction of the venue of the court was lost. This is because entering a plea accepts the jurisdiction. In this way, only subject matter jurisdiction could be challenged. If they say this is a matter at law, my defense against this jurisdiction is whether or not there is a damaged party. I do not ask them if this is an equity jurisdiction, because equity is not a criminal type of action. If they say this is a matter in Hustings, which is the true nature of all actions of administrative law, my defense against this jurisdiction is that I am not an artificial person, unless I am a federal citizen. But that is quite another matter, unless they can show from the records of the Secretary of State's office that I have chartered as such. If they say this is an admiralty matter, my defense against this jurisdiction is whether the offense was committed on federal territory, over which the state has retained concurrent jurisdiction. Although I still have not found out how the state exercises an admiralty jurisdiction in light of 28 U.S.C. Section 1333. If they say this is a military matter, my defense against this jurisdiction is that 1, I am not a member of the military, and 2, the nation is not under martial law. Or is it? Given the fact that there are currently 14 notices from the President of a declaration of national emergency published in the Federal Register, we may very well be in a state of martial law. The one from March 6, 1933 is still in effect. It's called the War Powers Act. However, they are not going to admit the nature of the action, as this will admit their want of jurisdiction on the record for all to see. So they move to dismiss the charges nearly every time. I contend that if only 10% of the people enforce their right to know the nature and cause of the accusation, we could most certainly shut down the incessant stream of revenue being fleeced from the people by these administrative courts. This is what I always say. I simply do not understand the nature and cause of the accusation with regard to the elements of personal jurisdiction, venue, and the nature of the action until the prosecution properly alleges them. I am therefore unable to enter a plea to the charge until I have had an opportunity to raise a meaningful defense against these elements. I cannot rebut an unstated presumption. The courts operate on silent judicial notice of presumption all the time. It's time for this to end. In America, our laws are comprised of several fundamental levels. The first is constitutional law, and no other law of any form is valid unless it comports with the applicable Constitution. A law that cannot find its basis in the applicable Constitution is an unconstitutional law, and thus null and void. At the state level, the next operative form of law is the common law. The government has done everything within its power to wipe common law from the face of American courtrooms. But the common law was, is, and always will be the proper form of law for the de jure state citizen. Some modern reviewers have stated that the common law is harsh. We might observe that it is unforgiving and inflexible when a person transgresses the rights of another. I am not convinced that this makes the common law harsh so much as it does strict. God's law is harsh. It's meant to be, so that people understand that they must obey the law. Equity law covers a broad scope of legal issues and is used extensively in today's courts. Equity is distinct from common law. Equity must always be voluntarily accepted, and there must be a contract nexus. In the federal system, jurisdiction always attaches by contract. What kinds of contracts do you have with the federal government? It is important to note that whenever the word fair is involved, it means that a third party will decide what is fair for you. Despite the lofty ideals of equity, what is thought to be fair in the mind of one person may oftentimes be thought to be completely unfair in the mind of another. If the common law is competent to provide a remedy, one need not acquiesce to the jurisdiction of a court of equity. This is where the savings to suitors clause comes in to save the day for us plain folk. Next would come statutory law. This is the form of law that most Americans know as the law, although it is a form of law with extremely limited power. Statutory law is comprised solely of the acts of the legislature that have become law and are currently in force. Most of these legislative acts, statutes, have been codified in one title or another within a set of codes. There are a couple of significant points to remember. First, most codes are not law, but are merely indicative of the law, called prima facie. The law is the actual statute, the positive law, that was passed by the legislature. It is conceivable that a statute could have been repealed, yet the code section still exists. If you are in a legal fight, always check the statute behind the code section. Second, keep in mind that not every statute passed into law is codified. Some statutes simply stand alone and remain non-codified, hence the name statute at large. When searching out what the law says, always look to the annotated version of the statutes. This is what the Supreme Court has said the law is. And here's a real kicker concerning statutory law. A statute is an enactment by the legislative body bringing into existence its creatures, i.e. corporations, and setting forth the privileges, immunities, and responsibilities of each creation. A statute applies only to the rightful subjects of legislation, i.e. the creatures created by the statutory fiat. The phrase rightful subjects of legislation does not mean the people, unless the statute specifically states its intent to apply to private citizens. Do you have a license? Is your name spelled in all capital letters on your credit cards and driver's license? You have a ton of contracts out there that makes you a person wearing a mask who is subject to the legislation written to control it, and you have to get rid of them. Of course, one should remember that one could create an obligation to a law that would not otherwise bind him by involving himself in various regulated activities or by entering into an agreement with the government, such as acquiring a business license, resale permit, etc.